I really appreciate the opportunity to come out here. I haven't presented my work in a while for reasons that might be obvious, and this is really just a great opportunity to get to kind of work seriously on themes that I've been thinking about for a long time, and I've been kind of wanting to make more rigorous and systematic. So since this is the first time I'm presenting my work here, I thought I'd start by kind of giving some context to the paper, which is part of a much larger puzzle that I'm building in my work. So in general, I'm interested in the ethics of punishment, and I take punishment to be quite a broad phenomenon. So I think of punishment as punishment that occurs in private relations between individuals, in institutional relations, and of course, in the primary case of criminal law, punishment at the hands of the state. So if punishment can occur in all these relationships, what kind of makes an act of punishment? So what makes something an instance of punishment, I think, on a pretty non-controversial conception of punishment, is that it involves the deliberate imposition of some negative treatment, something unwelcome, whether it's burdens or harms or suffering on another in response to wrongdoing, in response often to culpable wrongdoing. And the puzzle about punishment is, of course, that we generally think that deliberately harming people is impermissible. And in the case of punishment, we often think that it's not only permissible, but required. So how does that happen? So the project, that kind of the general project, is to work out the mechanics of punishment. And in the past, I've sort of considered different reasons that there are in favor of punishment, and broadly defended a desert-based conception of punishment, but also tried to work out the role and significance of all sorts of other reasons in favor of punishment that are obviously in the literature, whether it's consequentialist reasons, reasons relating to do with duties we might owe to victims, expressivist reasons, and see how these all work together to kind of come together to a picture of legitimate justified punishment. And I think that a basically desert-based but integrated conception of punishment is also compatible with humanistic concerns. So concerns about the interests, rights, and well-being of persons, despite what you might think of as kind of an initial tension, if not direct conflict, between humanistic concerns and deliberately harming persons. So I think those things do come together. And the part of the puzzle that you're reading, the paper on second chances, might be thought of as reflecting kind of part of the humanist picture of the puzzle. So developing what I take to be an underexplored set of reasons we have, in some instance, to refrain from punishment in cases which might otherwise be thought of as just, appropriate, or proportionate on whatever theory of punishment we think it is that makes punishment permissible or even required. So you don't have to take up my theory. It's not even part of the paper. We can be pluralists about what actually justifies punishment, but assuming a theory of punishment of a certain kind, so I'll talk about that in a minute, that kind of sees punishment as a practice of accountability, of holding people responsible, rather than, say, managing persons and just managing risk. If you take that as kind of your background theory, then we're going to have duties and reasons to impose punishment, but also sometimes duties to refrain, or what I call cut wrongdoers a break. And I think this is going to be true, as I said, in all practices of punishment, so private, institutional, and state punishment, but also importantly, in the case of criminal punishment. And why should we refrain? Why shouldn't we always impose justified, proportionate, appropriate, whichever your favorite kind of way of putting it is? What I call, just to kind of cover all of these different ways of thinking about punishment, full punishment, right? That's kind of justified on your theory of punishment. Why not always impose full punishment? To sum up the entire paper in a line, because of human fallibility. Because recognizing human fallibility requires forbearance in the imposition of just punishment. And that's the argument that I'm going to try and defend today. So to motivate kind of the intuition that kind of lies behind the claim, just imagine someone who's entitled to punishment in a wide variety of kind of occasions. It could be a private case, an institutional case, or again, the state. And that agent punishes on each and every occasion in which they're entitled to punish, for each and every wrong and to the full extent of punishment. It seems like if we shift our gaze, so often when we're thinking about justified punishment, we're focusing on the defendant, on the offender, on the wrongdoer, what they've done, whether they manifest disrespect for others, whether they're violating some value. And if we think about just the agent and the action, then we're going to get to the conclusion that on this particular case, and we're just going to stipulate that in the cases that we're thinking about, punished would be appropriate, it would fit the crime, the person ought to be punished. If we shift our gaze away from the punishee over to the other party to the punishment relation, that is the punisher, and think about the ethical limits of punishment activities, seems to me at least, and this is kind of the thought that I'm trying to defend, that always punishing in every instance in which you're entitled to punish, the full extent of permissible punishment is in some sense harsh and over-exacting, which I thought, and that's why it's at the beginning of the paper, is nicely captured in this line from Seneca, where he says, it's a fault to punish a fault in full. Right, so this is what the paper is trying to get at, that this general standing reason that we have when we're engaged in a practice of punishment, not to always impose full punishment. Now, the grounds that I'm developing in favor of forbearance in the paper, the idea of fallibility that I'll speak more about in just a moment, is, I think, an idea that's quite familiar in non-legal contexts. So certainly in religious contexts, where ideas of grace and mercy and, well, it depends on the religious context, but there's certainly a lot of religions where human fallibility sort of plays a role in how a divine punisher would punish humans, but also in popular culture and in important sort of literary texts. So think of the famous Alexander Pope quote where he says, "To err is human," or to take just a song that's kind of popular, it was 10 years ago when I was still after all, right? So this, right? So I'm only human, just to say it's kind of in the popular kind of imagination. When we say something like, "Forgive me, I'm human," I don't think we're saying that we're not responsible for our actions. I think what we're saying is that we're trying to appeal to some deep connection between the types of beings we are and our tendency to err or fail. What we're trying to do, I think, is to call attention to the vulnerability to failure that's kind of inherent in human activity and in human life, and requesting that when someone responds to our wrongs, reacts to our wrongs, and poses consequences owing to our wrongdoing, they should take that vulnerability to failure into account. So on the one hand, the idea is quite familiar. On the other hand, I don't think that it's been formally, or at least it's failed to find its way systematically into this criminal legal system. And I take that to be a problem. So the project of the paper is going to be to suggest that our punishment practices have to be moderated to recognize fallibility. They might do this sporadically. You know, there might be a judge who happens to take themselves to kind of be giving second chances, but I think it has to be recognized. And that our systems are excessively punitive if they don't. And so we need to find legal mechanisms that allow us to extend second chances, and that's what the second part of the paper is engaged in. And I'm going to try to now develop that common sense idea of fallibility and make it kind of more precise so that we can develop the implications for criminal law. Just before doing that, I want to distinguish my argument for restraint from two alternative traditions or projects that are also interested in restraint and punishment, kind of come up in the beginning of the paper, just to say that my project is slightly different from those projects, one ancient and one quite contemporary. So the ancient tradition that I distinguish my work from is the mercy tradition. And if we think about the work on the tension between justice and mercy, I think defenders of mercy certainly defend the value of restraint, of forbearing from imposing everything we think of as just punishment. Often in terms of kind of a virtuous disposition of the mind in favor of leniency rather than exacting justice. But this kind of line of thought, or this tradition, while possibly animated by very similar ideas to what underlies the kind of second chance proposal that I have, I take it to be adequate, at least in my context, because mercy is generally understood as gift giving, as optional, as supererogatory. It's something that a person in the position of, or who has the authority to punish can extend, might virtuously or supererogatorily extend, but it's never required, at least on conventional understandings of mercy. And I want to defend principal reasons to exhibit restraint that generate a duty to forbear, something that we can owe to the punishee themselves. So that's why it's different from the mercy tradition. And second, I'm going to distinguish my second chance proposal, simply because linguistically it's really highly related, from second chance initiatives that have become the subject of kind of much interest in the American legal context and also other jurisdictions as well, where there's an interest in giving essentially second chances to offenders who have served very long sentences and kind of reconsidering what the criminal justice system has done to them and whether it was ultimately correct, just, proportionate to have given such a long sentence in the first place. So what's become known as second look legislation is very popular, well, until about 5 years ago in the US, kind of the interest has somewhat died down, but people working on the field say that even though there's a lull in the political interest, there still is kind of small achievements to be found. So, for example, the recent 2018 model penal code suggests, in fact, that all criminal legal systems in the U.S. adopt a resentencing regime whereby every 10 to 15 years, if someone has a very long sentence, that sentence is relooked at, made sure that it still comports with contemporary penal purposes that are considered legitimate, that it wasn't disproportionate, obviously in the American context, because it was a drug crime that was disproportionately sentenced. But this isn't only happening in the US. So we also have the European Court of Human Rights case in 2013. There was the Winter case that held that irreducible life sentences violate Article 3 of the European Convention of Human Rights, so that if a legal system imposes a life sentence in a way where there is no possibility of resentencing, of taking a second look, giving a second chance at life to the offender, this is unjustified. So this is, again, somewhat related to the kind of work that I want to do. But notice that these proposals are generally interested in correcting injustices. Right? So they're interested in reducing disproportionate sentences. They're not interested in moderating what I take to be just sentences, warranted sentences to begin with, which is what I want to talk about. I want to talk about, of course, if there are injustices, of course, if there's discrimination, of course, if there's disproportionate sentences, there's independent reasons to now go back and make sure that what people are saying is just. This is kind of just an independent point. But beyond that, if we impose full sentences perfectly in each and every case that are fully just and warranted, that we've already come to term that, there's still reason for restraint. And that's why this project is kind of promoting more, I would say, restraint. So. You can just keep talking till we'll work it out. That's fine. So the logic that I want to propose essentially says that we have reasons to moderate our punitive practice and give people a break. And we should do so. This is kind of, I'm just going to repeat what will be in the slide when it shows up. At the outset, not after someone has served an excessively long sentence. But actually, at the moment of judgment, we should recognize their fallibility, I'll suggest, and recognize that restraint is in order at the outset. And that's because of a fact relating not to a defect of the particular punishment, but a potential defective practice of punishment, right? One that ignores fallibility. So those are 3 points. We're restraining from just punishment at the outset, because otherwise we'll have a defective practice. Okay, so now I'll actually use the slides. Here's the plan for the rest of the talk. First, I'm going to talk a little bit about essentially the background within which the fallibility argument is advanced, an approach that tells us what justifies accountability practices, so blaming, punishment, holding people responsible in general, because that's kind of going to be the background for the argument in favor of fallibility leading to restraint. Then I'm going to talk about what I mean by fallibility. What is this relevant feature? I'm going to define the concept. Third, I'll present the argument for forbearance on ground of fallibility. So why should fallibility lead to forbearance, even if we agree descriptively that it's there? And finally, I'll offer a concrete proposal for how and when second chances should be extended to wrongdoers on grounds of fallibility, and that's the reliability proposal. So 1 through 4 are basically the normative argument of the paper. Next, I'll look at second chance mechanisms in criminal law that we can use to implement the proposal. And 6 isn't in the written text because it hasn't been written yet, but if I have time, I'll say a few words about how this fits into the sociology of punishment and how we think of offenders who bring the law. It's kind of a piece that hasn't been written, still debating whether it should be part of this paper. Okay, so to start, we need some background on accountability practices and what justifies holding people to account, on blaming and punishing them in the first place. So on the best justifications of these accounts, and of course, this is my understanding of what's best, recognition of a central aspect of what it is to be a person, that is moral agency, plays a major role in the justification of accountability practices. So if we think for a minute about what moral agency is, it's usually understood as a set of features or capacities that people have, which make them subject to moral demands in the first place, right? They make them the proper targets of responsibility and accountability practices. So on some accounts, this is going to have to do with the kind of choices we're able to make, or the kind of calculations we can make in anticipation of our decision-making and action, or as it's commonly, I think, in kind of contemporary ethics stated, moral agency is related to the capacities we have to recognize reasons that apply to us and to act on them, or to act in ways that deviate from them. So recognition and acting on reasons being kind of very central to this conception of moral agency. And of course, an agent who lacks these capacities is simply not going to be a good target for blaming in punitive practices. We may need to manage them, we may need to do other things, but holding them accountable just seems inappropriate because they don't have the very capacities that would make them responsible agents. So again, recognition of moral agency, these justifications explain call for holding agents responsible for their actions and where relevant for punishment, rather than other sorts of responses we could have, such as managing risk or just fixing the situation. They call for holding people to account. So let's just take a case. Suppose there's a person and they sort of deliberate what they ought to do and they decide to mug and assault you. All right, so they kind of consider their options, they make a decision, and then they act. There are some views according to which the right responses to wrongdoing are broadly positive. That is, what we need to do is sort of express sympathy for the background which brought you to act in the relevant way. We need to extend aid to all the parties involved, victims, of course, but the wrongdoer themselves, because they need to be aided in order that they will be able to live kind of a normative life in compliance with the law. You might have pity, sympathy, express love, this kind of set of responses. And all of these responses might be apt, but the point of these kinds of accounts is that where there's moral agency involved, right, where the agent has the relevant capacities that we're talking about, addressing that person merely as a victim of tragic circumstances in a way that doesn't regard their agency and hold them accountable for their action is a moral failure. It's essentially to see them as an object or a patient or a pawn, something to be moved around, something to be dealt with, something to be fixed. And in fact, because the person who acted as an agent, we should take that seriously in our interactions with the agent. We should see her as the author of her actions and therefore hold her accountable, which in the relevant cases includes blaming and punishing. Okay, and this stands at the base of what I think of as the relevant justifications of a punishment, which state that recognizing agency calls for blame and sometimes punishing people for their wrongs. So we can't remain in the exclusive kind of fix-it register. But, and here's a point that I think is missed in these discussions, while I think it's true that responses that fail to recognize agency are going to be failing in some morally important way, treating people as pure moral agents can be problematic as well, right? So treating people as though they have the capacity to act on reasons without taking into account that they are not pure moral agents, and I'll get to what this means in a minute, is also going to be problematic. And sort of a data point or a piece of evidence for this fact, I think, is found in the fact that even where people are responsible and should be punished, it still seems to me perfectly appropriate to have these positive responses. Sympathy and trying to help people in recognition of where their crime came from. I think all of these reactions go together. And that's because I want to suggest there's a further feature of personhood beyond moral agency that has to be recognized in our interactions with others and in the responses to how they act. And that is the idea of robust human fallibility. So what is fallibility? And here I hope you'll help me if you think this isn't clear enough, because this is kind of an important piece of the puzzle. So fallibility refers to, I want to say, in conjunction with peace. So first of all, it's the very capacity of persons to engage in culpable wrongdoing, right? Their in principle capacity to fail normatively, to fall below what can and should be expected of them, and in ways that manifest their disregard for objects of value or for others. But it's not just the very capacity. So to having a capacity fail makes it kind of potential that I might fail. It's more than that. It's also our capacity to fail in conjunction with the imminent or phenomenal context of human action. I mean this in the Kantian sense, and let me just say what I mean by that. It's that persons not only have the capacity to fail, but they're also embedded subjects. They're embedded in the world, they're affected by the world, they're subject to temptation, emotion, impulsivity, limited in a wide variety of ways that we can kind of further talk about, all of which make moral failure more than a mere potentiality. It's a fact, I think, of human life. As I put it in the paper, and I'm just going to quote this for a minute, while full compliance need not be a logical impossibility, moral failure is part of even the most morally triumphant human life. It would in fact appear to be superhuman if moral perfection were to be achieved by any single person. And there's a reference, of course, to Christian ideas of the only morally perfect being emerges, right? In the end, turns out to be the divine, right? So these ideas are certainly in religion, and I want to kind of bring them down without relying on religion to just sort of be the kind of idea about personhood that we can accept. While a being without the capacity for such failure would be virtually unrecognizable. These are fundamental features of ourselves, of the persons with whom we interact, who are not at the end of the day merely moral agents or pure subjects. Rather, while human persons have agency and the capacity for moral achievement, owing to the capacity to fail in conjunction with our embeddedness in the world, moral failure is an inherent part of the human condition. And as I said before, sometimes when we claim that we're human, what we precisely mean is something about this, right? So here, the claim is that essentially full compliance with morality is overly onerous. People simply can't meet the full normative demands that apply to them on all occasions in which they are demanded. And so morality turns out to be this aspirational rather than achievable project. So that's the idea of fallibility. But what does that have to do with punishment? So just as recognition of moral agency had implications for how we're going to react and hold each other accountable, I think recognition of fallibility has implications for our accountability practices as well, right? So just to make it clear, I don't think fallibility changes what the first person deliberation is like for someone who's trying to decide how to act, right? I have a dilemma before me, moral reasons apply, and I ought to act as morality requires in each and every instance. But the idea that diachronically and in the aggregate, there are going to be failures means, I think, that this should have an effect on how other people stand in judgment, blame, and punish other people. And this is because to punish persons in every instance, so this is the first point, in full in every instance of wrongdoing, is to punish under a demand of perfect compliance, and in so doing, to hold persons to what I've just laid out as a utopian standard of behavior. Right? So in one sense, and from the discrete perspective, looking at this one act where I violated a norm and I did so under conditions of culpability, punishment should be required. That's from the discrete perspective. If we look, again, diachronically over time, and in the aggregate, it turns out that understanding or recognizing that we can't fail to fail should have implications for the way we punish one another. And as I said, I think that this point is sometimes overlooked because we're constantly restricting ourselves to the discrete perspective. We're not thinking about the implications of a full overtime practice of punishment. But once we move beyond the discrete analysis, we're in a position to see that perfectly imposing full punishment is criticizably over-exacting, and it would be wrong. And that's what I was looking for as opposed to the mercy tradition. It would be wrong to punish in full in every instance in which we're entitled to do so. Rather, as I said, we have to punish less, and that is, I want to suggest, to extend wrongdoers a second chance, at least sometimes, in recognition of their fallibility. Otherwise, despite what our theories tell us in discrete cases, we'll be over-punishing, right? So perfect punishment turns out to be over-punishment. So just to, again, compare this to other ideas of overpunishment, the idea of overpunishment is everywhere in the literature, but it generally refers to the imposition of disproportionate punishment, particular punishments that are excessive given the discrete analysis of what the wrongdoing was, what the culpability was. And in this analysis, I'm offering, I want to point to a different, and it's a non-competitive, right? So all these forms of overpunishment might be around. Species of overpunishment, one that goes not to the inappropriateness of the particular punishment under the circumstances, but to the defective practice of punishment that holds persons to an overly idealized standard of behavior, right? And I just want to highlight before just taking a moment to think about how this relates to criminal law, that a feature of this fallibility argument that I've defended is just to see that, notice that I haven't here in any way appealed to features of particular kinds of wrongs. So I'm not talking about this being relevant because something is relatively minor and so it's easy to neglect it, or because it's common and we all do it. And so, for humility reasons or something like that, we should show tolerance. Those kind of features are features that go to the discrete analysis of which kind of wrong is involved and what can we say about it. This fallibility analysis applies sort of across the board. As a matter of practice, somewhere I have to forbear, and I haven't yet said when and where I have to forbear. But it might apply in any case of moral failure. So just kind of to preempt a question that might come up at this point is that I've now argued that we have a reason to forbear on grounds of fallibility, but you sort of might ask, the way I've set up the argument, how does this relate at all to criminal law, right? After all, legal systems don't engage in policing compliance of all the moral norms. That's hopefully not what they do. Yeah, it depends who you ask, depends where you ask and when you ask, but that's not what it's supposed to be doing. So I'm going to assume kind of a legitimate criminal law. It's a system that punishes for failures with compliance with some sort of legal conception of wrongdoing, not strictly moral conception of wrongdoing, right? So we have a circumscribed set of wrongdoings. So maybe criminal punishment doesn't even have to recognize fallibility, because punishing some rather than all already gets me into a circumscribed place that perhaps kind of the logic of fallibility doesn't filter into. So I just kind of want to preemptively say a word about this, because obviously I think this is relevant for criminal law. I'm not going to be able to talk too much about the relationship between legal and moral norms, right? We can have an entire seminar about that. But generally, a kind of criminal law, I would say, is set up to police a subset of wrongdoing that bears certain features. There are different theories about what this is. Maybe what makes a wrong relevant to the political sphere is that it's relevant to ensuring sort of civil coexistence, or you might have a Duffian conception where public wrongs, anything that's relevant to the polity, is the kind of thing we could police. Not everything, but just this circumscribed set of wrongs. But the animative ideas that are going to carve out the criminal legal space, right, that are going to define what is this legal conception of wrongdoing that we're restricted to, notice, are kind of completely arbitrary from the perspective of fallibility. That is, they pose restrictions on the practice of punishment, but in ways that aren't at all responsive to the kind of concerns we're interested in. And so I want to suggest that punishers won't be immunized from the requirement of recognizing fallibility and the way in which, to err is human, and so we have to forbear a little bit, just because there's a restriction in the practice of punishment, if that restriction has nothing to do with the concerns of fallibility. So say I commit, as a state, to only punish wrongdoings committed on Tuesdays. I think then you can see how circumscribing the wrongdoing that I relate to doesn't mean that when there's a wrong, a failure that happens to fall within the purview of what I've committed to punishing has now immunized me from having to take into consideration the kind of the relevance of fallibility for how I respond. And I think that this is kind of generally the case across the board. And that's why the logic of fallibility is going to continue to exert pressure to forbear on punishers, even if there's different ways in which our punishment practices are circumscribed. So I'll just say the law, when it punishes legitimately, is only going to punish those kinds of wrongs it has the authority to punish. And it's the same in private relations, right? If I have a friendship that's set up in a certain sort of way, maybe my friend can punish me when I, demean the waitress at dinner, but has nothing to say about what I do to my spouse. But the fact of restriction isn't enough to immunize us from the logic of fallibility. What we have to do is restrict our practice in a way that is responsive to the concerns of fallibility, which is what I want to suggest we can do by adopting the reliability principle. Okay, so we have the reason to forbear, but when should you forbear? So here my suggestion is, if the entire problem is holding people up to too high a standard, to the standard of perfect compliance, what's called for is punishing against a lower, more modest standard of compliance, essentially a fallibility-sensitive standard of compliance. And here's my suggestion. And the term reliability, I'm not married to. So I'm looking for something that's fallibility-sensitive, that's less than perfect. reliability is something that kind of appeals to me right now. But again, if you have thoughts about that, the idea is something that's fallibility sensitive, not necessarily an idea of reliability, but here's the proposal for now. Given human fallibility, what we can legitimately expect of persons on the whole, rather than from the discrete perspective, is that they reliably act in accordance with reasons and duties that apply to them, right? And this means that insofar as a wrongdoer meets the reliability threshold, right, doesn't violate reliability, only violates perfect compliance, they should be given a second chance. We should restrain ourselves from punishing. So we have the duty to punish, but there's also a duty to forbear. In this case, again, a duty to extend second, and I don't mean second to exclude third, I just mean, somewhere down the line. Chances in recognition of the fact that despite their infraction, they might still meet the reliability threshold, even if they don't meet the threshold of perfect compliance. So the claim is that we have a duty to extend second chances to wrongdoers in recognition of the fact that they haven't violated the fallibility sensitive standard of compliance, that of reliable compliance. And where we impose punishment consistent with this principle. So when someone has violated now reliability and then I impose full punishment, that's going to be perfectly consistent with the kind of logic I propose. Okay, so that's the proposal. It, of course, leaves a bunch of questions open. I'm just going to name a couple of them. And of course, I'm sure you'll challenge me to deal with others. One is that I haven't yet said anything that commits us to whether we ought to be remitting punishment altogether for something like a first offense, or whether what's in order is mitigation. Nothing I've said commits us to either picture. I also haven't said anything about the time slice over which we're kind of thinking of the problem of aggregation. So is it a whole life view of infractions, or suppose, let's say I commit a theft and I'm given a second chance and I actually, get back to normative behavior, and for 20 years I don't offend, but then there's a reoffense 20 or 30 years down the line. Am I looking at a new time slice? So I haven't given any information that lets us answer this question. And of course, where the reliability threshold is exactly. Project hasn't yet worked that out. So we have a host of questions. But what I do hope to have shown is that we have reasons to give wrongdoers a break and refrain from imposing full punishment. So back to the original slide, we should do so at judgment, right? Not wait 20 years in to start giving people kind of a second chance. And if we fail to do so, that constitutes a defective practice of punishment because it holds people up to a utopian standard that they can't meet. So that's the normative argument. And in the few minutes I have left, I don't know how long. Or should I stop?
Wrap up so that.
Yeah, we're wrapping up. So I'm not going to go through this. There's a lot of this in the paper. In the second part of the paper, what I do is I look at the legal system and I want to see if this can be easily implemented, or whether we need to make radical changes to criminal law in order to extend second chances. So I think that as a matter of systematizing this idea, that would be a radical change, but that we do have mechanisms in the law that are already sort of natural avenues through which we can extend second chances. The first one of this, there's very few legal systems which actually have progressive loss of mitigation. It used to be quite popular in England, but it no longer is. But it's my favorite one, so it's there, even though most legal systems don't have it. And progressive loss of mitigation is kind of a doctrine by which it dictates so when you come in with your first offense, you're going to get an immediate reduction, sort of in view of the fact that this is kind of entry into criminal law. You might still kind of pick yourself up and do well, and it gradually sort of diminishes through subsequent convictions until at some point you reach the ceiling where you're going to get sort of full proportionate, whatever it is, punishment. This is a doctrine defended by Andrew Ashworth and Andreas von Hirsch, but no longer used in the UK. It is slightly used in other places where something on like the fourth conviction in Sweden, you get the full incarceration, but before that you won't. So it does exist. Most jurisdictions have a much more popular first offender discount. So this is essentially a mitigating factor in punishment, is that you have no prior record, and that can be worked, although it needs some work, into kind of a legal mechanism for giving second chances. Suspended sentences is where you have a conviction, but we suspend essentially the harsh treatment that comes. So you get the censure, but not the sanction. Over a period of time where if you don't reoffend, then you're not going to have to bear the consequences of action. And deferred education and discharge order is effectively where there's the possibility of no conviction. So in the US, at least, the court first receives a guilty plea. So there is something to base the guilty plea on, but doesn't convict. It defers the actual judgment, not just the kind of carrying out of the sentence, until such time as you prove, again, that you're reliably not violating criminal law. At which time, if you do, then you won't even have a conviction. So that's really kind of a clean break from the criminal law. And I say a word about why, although that's kind of a cleaner second chance, I have worries about non-conviction, because I think the logic of fallibility that I propose doesn't give us reason not to call out a wrong and to determine that someone's responsible, but it's a reason to kind of suspend the consequences. And that's, of course, only if conviction doesn't mean there's a lot of consequences, and in most legal systems it does, but just to kind of have the moving parts. And of course, the prosecution and the police can also prevent, also not a favorite of mine. So I'm not going to say anything about the sociology of punishment because I don't have time. Maybe just one word. So this kind of part of the project is that in the cultural imagination, actually in professional writing and legal doctrine, there's kind of imagined offenders that we work with. There's the idea of offender as, so I'll take the second one, a patient or sick. And usually that leads to kind of medicalization of treatment and punishment. There's ideas of, say, the US in the 1990s and 2000s, the idea of the offender as a super predator, which kind of was a dehumanizing idea that thought of kind of a certain subset of offenders as depraved and led to certain sorts of treatment. So I just want to propose that the second chance proposal, you know, right idea is committed to the idea of someone who's convicted as a person who's failed. And that might be a better kind of sociological idea to work with in kind of developing and thinking about punishment, but that's really in its infancy. So thank you very much.